The proposed amendment would return New Hampshire to her court structure prior to 1966. The structure is historically proven in New Hampshire, but relies on her unique characteristics to retain an impartial judiciary. The structure would likely be inappropriate in most states. Hi, this is Representative Davenport from the New Hampshire House. In this video, I present arguments for Constitutional Amendment 25, which I have sponsored. I use concepts introduced in my previous video, The Structure of Liberty. Please watch that first, or the parts of the model I use may not make sense. CACR25 is a constitutional amendment to remove Article 72A from our state constitution. Article 72A was added by constitutional amendment in 1966. It states the judicial power of the state shall be vested in the Supreme Court, a trial court of general jurisdiction, known as the Superior Court, and such lower courts as the legislature may establish under Article 4th of Part 2. CACR25 will not remove the independent judiciary, but will rebalance its location so that the court can perform its duties. Currently, the New Hampshire court is permanently elevated above the executive and legislative branches, is acting without a check on its powers, and is behaving in an unconstitutional manner. To see why, we need to look at the interior mechanisms of what is called the positive sovereign, and for that we need to go back and look at our executive. What you could call administrative states, police states, dictatorships, or monarchies have been around for millennia. That is, we know that kings and their noble courts can exist without legislatures. Legislatures, on the other hand, do not exist for long without executives. Kings would, and do, claim authority based upon divine rights, or by claiming that only they authentically carry the will of the people. A king in this position we will call the sovereign, meaning above. The United States Declaration of Independence, in a radical concept for the time, and frankly still radical today, rejects the notion of a sovereign executive and declares that the people are the source of sovereignty. So let's say the people reside here in the blue area. Let's zoom in on that for a moment. Here we have a town with private property, and at the tip of the private property are houses. In the houses, individuals have their greatest amount of freedom and are most protected from the laws of the group. You might walk naked from the bathroom to the bedroom. I wouldn't suggest you doing that in the town square or even across your front lawn. In their home and on this private property, you could say that the individual has the most sovereignty. So the people reside here in the blue area. The people come together in the center and by supermajority approve a structure of government. The people delegate or loan to this body a portion of sovereignty, a consent to be governed by this structure within constraints designed by them. The center of this delegated authority resides in the legislative branch of government, not the executive or judiciary. This delegated authority is called the positive sovereign. If you'll excuse my geekish excitement here, the method used to anchor the positive sovereign to the legislative branch, to pull it down from the executive, and also why it's called the positive sovereign, is one of the coolest things I learned studying constitutions. Works like this. There are two chambers in the legislature, the House and the Senate. Altogether, both cover the same area and the same number of people. They are bound together because they are the same type of branch with the same basic powers, and because legislation must pass both chambers to make it to the governor. But they take on different flavors or colors because one picks up on local sentiment and one picks up on broader sentiment, and they may each be controlled by different parties. So we'll visualize our two legislative chambers here as two circles of different colors and give each a charge of plus 2/3 so that they total up to plus 1 1/3. We will then give it our executive a charge of negative 1/3 to represent his veto power. But we visualize this power down below the legislature because when exercising the veto, the executive is trying to prevent the rise of the power of the legislature. So to become a law, a piece of legislation must have a positive charge of at least plus 1, which is why this is called the positive sovereign. And the relative charge weighting and the executive jumping to two different positions above and below the legislature keeps the location of the positive sovereign bound to the people's representatives. There are other checks to protect the location of the positive sovereign. For example, the executive has no power to authorize any action against the legislature or judicial branches, and the legislature is the body that can impeach members of the executive and the judiciary. So what does this have to do with the court? The court wasn't even part of the formation of the positive sovereign. Exactly, because the role of the court is to be neutral, a referee, to have a charge of 0. It needs to be neutral for its two major roles. The first role is where an entity from the blue area, that would be us as individuals, which we will now call this negative sovereign, is prosecuted by the executive branch for violation of a law passed by the legislature. That is, we all want to get a fair trial. The second role is where the positive sovereign is attempting to loosen the chains the people have placed upon it. From its neutral position, the court may block the state by declaring a law or action unconstitutional. That is, it may side with the negative sovereign, the people, or the positive sovereign, the state, depending on the Constitution. The judiciary in New Hampshire is not only failing to perform its role as impartial referee, but is itself violating the Constitution. To see why, we need to look at how it is formed. In New Hampshire, we have a governor and an executive council, which is also elected from districts like the Senate. My apologies to the council, you're not formally in my animation rig yet. The council is shown the same color as the governor, but may and is presently controlled by a different party than the governor. In New Hampshire, the governor appoints a justice and the council approves, and justices have a term of good behavior. This takes care of the partisan balance of the court, but there is no legislative branch involvement in the appointment process. A common way of involving the legislative branch is to have the Senate approve the appointment. New Hampshire didn't use that method because the New Hampshire Senate, with only 24 members, is very pointy, and so attached to things such as big business structures. This large difference in size between the House and Senate is intentional to more clearly separate local from state matters. So New Hampshire didn't use the Senate for confirmation. Instead, prior to 1966, the balance was created by something analogous to a parliamentary vote of no confidence. If the legislature felt the court was favoring the executive, in effect forming the equivalent of a king and his nobility, they would dissolve the court system. The legislature would then clean out the judges that were not being impartial, and the executive would reappoint new judges. Since 1966, the ability to dissolve and reconstitute the court has been removed. Even before '66, the court had not been dissolved for over 60 years, giving lie to the notion that the judiciary was not sufficiently independent to perform its role. In the 1800s, with the great changes of the Industrial Revolution, the procedure was only performed 5 times, on average every 20 years. A reasonable interpretation would be that the people were adjusting their court through changing times using a bottom-up mechanism. In closing, I'll give 2 quick examples of judicial overreach. The first is the Claremont ruling. Here the court took a phrase from the Constitution that had been interpreted in the same way for 200 years and turned it upside down, ruling that the state was required to use a statewide tax to pay for education. In this ruling, the court violated separation of powers by adopting the charge and flavor of the legislature, making it one of the least representative legislatures in the world. The second example is more recent. The House passed a bill ordering the Attorney General, a creature of the executive, to join the Obamacare lawsuit. The AG countered that he would take us to court over the matter. The Senate asked for an opinion from the court. There is only one correct answer, which is this. This is none of our business. The balance of power between the executive and legislative branches is completely determined by the resolve the legislature shows in defending the location of the positive sovereign. Thank you for your consideration.